This episode was produced by Bach Pro Se. Run your own legal research at prose.trybach.com.
I let my child stay with my mother, sister, aunt, or another relative while I got back on my feet. Now they don't want to give my child back. Can they legally keep my child?
Yeah, that is a terrifying situation for any parent to face.
It really is, and it's exactly what we are pulling apart today. We are looking at Florida Chapter 751, and we're acting as a guided legal research briefing for parents who are facing this exact scenario.
Right, because the stakes they couldn't be higher for these families.
No, they couldn't. So we have the Florida statutes, we have procedural rules, and we have the case law right in front of us. And we are looking at extended family custody strictly from the parent's perspective today.
Okay, let's unpack this. I think we have to start by dismantling probably the biggest myth out there, which is the idea that time equals custody.
Yes. It is such a pervasive misconception. People assume that if a child lives with an aunt or a grandmother or a sister for an extended period, say several months or even a year, that relative just automatically gains custody rights.
Like it just magically happens over time, right? Or worse, the parent assumes they've somehow forfeited their right to have their child returned just because they've been gone for a while.
Oh, wow. So just because a grandparent has been, providing a roof, feeding the child, and taking them to the pediatrician, none of that erases the parent's rights?
None of it. The duration of the stay, the financial support, enrolling the child in school, or even holding a medical authorization letter, those things do not magically dissolve parental rights.
Okay, so the law doesn't just punish you for asking for help?
No, absolutely not. Florida law actually recognizes that parents face crises. I mean, a parent might lose housing or face a medical emergency or just go through a severe financial hardship.
Yeah, that happens all the time.
Right. The law does not penalize a parent by automatically stripping their rights just because they did the responsible thing and accepted temporary help from their family.
It makes me think of this simple analogy. It's like letting a friend borrow your car while you're out of town for a few months.
Okay.
Your friend might put premium gas in it, right?
Yeah.
They might pay for an oil change. They drive it every single day. But that doesn't mean the title of the car suddenly transfers to their name at the DMV. Like, the title is still yours.
That's exactly it. The ownership or, the fundamental parental right remains with the parent, regardless of the maintenance provided by the relative.
Right.
But because the relative does need to be able to enroll the child in school or get them emergency medical care, the law needed a mechanism to allow that without transferring the title, to use your analogy.
Which brings us to the formal statute, right? Chapter 751.
Yeah.
Because if informal agreements in time don't legally transfer rights, there has to be a legal avenue for a relative to get official authority.
Yes.
And the Florida legislature created two very distinct paths here.
What's fascinating here is how Florida law created these distinct tools to help relatives provide care without automatically severing the parent's ultimate authority.
All right, they want to keep kids out of the foster care system if family can help.
Exactly. So they engineered two options: concurrent custody and temporary custody.
Let's pull those apart because they have vastly different impacts on a parent. What is concurrent custody under Section 751.05, subsection 4A?
So concurrent custody basically means shared rights. The extended family member is awarded custodial rights to care for the child concurrently, meaning at the exact same time as the parent.
So it doesn't take anything away from the parent at all, like zero rights are lost.
Right. The statute explicitly states that concurrent custody does not eliminate or diminish the custodial rights of the parent. The parent can obtain physical custody of the child at any time.
Oh, okay.
It's essentially a legal tool that lets the relative handle day-to-day logistics, like signing a school permission slip or a medical consent form without stepping on the parent's ultimate authority.
But temporary custody, which is under Section 751.05, subsection 4B, that functions entirely differently.
It does. Temporary custody actually transfers custody to the relative. It is subject to court-approved conditions, and it actively limits the parent's ability to just go and retrieve the child.
Wait, really? So if a temporary custody order is in place, the parent can't just show up and take their child home the way they could under a concurrent arrangement?
Exactly. They cannot just show up. The authority has officially shifted for the time being.
Hold on. If a grandparent is the only one feeding this kid and providing a stable roof, how does the court decide which path to grant? Because in the scenario we open with, the parent wants their child back. What happens when a parent disagrees with the relative's petition?
Well, the legal machinery hinges entirely on a single, powerful action from the parent. The operative legal trigger in Chapter 751 is when a parent objects.
And we really need to emphasize that word. The parent objects. It's not just a lack of consent or like failing to sign a paper. It is an active objection.
Yes, when a parent objects, the legal landscape shifts dramatically. But the consequence of that objection depends on which type of custody the relative is actually asking for.
Okay.
So if a parent objects in writing to a petition for concurrent custody, that shared custody we just talked about, that objection entirely blocks the petition.
Wait, so objecting to concurrent custody acts like a brick wall stopping the petition cold. But objecting to temporary custody is more like changing the rules of the game to make it incredibly hard for the petitioner to win.
Yes, that is perfectly stated. So for concurrent custody, under Section 751.05, subsection 3A, the court cannot grant it if a parent objects in writing, even if the other parent happens to consent.
Wow, it just completely stops it.
Completely. The petitioner, the relative, is then given a choice. They must either convert their petition to one for temporary custody, or the case is dismissed without prejudice.
Without prejudice, that's legal speak. Does that mean the relative can just turn around and file it again tomorrow, or are they, like, banned from trying again?
It means the door isn't permanently locked, but this specific petition is dead. They can't proceed with that concurrent custody case. If they want to try again, they have to start over, usually by filing for temporary custody instead, assuming they believe they can meet that higher legal standard.
Which, like I said, changes the rules of the game entirely. Because if the relative is seeking temporary custody under subsection 3B and the parent objects, the petition isn't blocked, right?
And it is not blocked.
No.
But the standard the court must apply changes drastically. If the parent objects to temporary custody, the petitioner must now prove that the parent is unfit by clear and convincing evidence.
How high is that bar? I mean, is clear and convincing evidence like beyond a reasonable doubt in criminal court, or is it a lower hurdle than that?
It sits right in the middle, actually.
Yeah.
It's not as high as beyond a reasonable doubt, but it is significantly higher than a preponderance of the evidence, which basically just means more likely than not.
Right.
Clear and convincing means the evidence must be highly and substantially more likely to be true than untrue. The judge must have a firm belief or conviction in its factuality.
So the relative is suddenly forced to prove I'm an unfit parent with highly convincing evidence. But what does unfit actually mean to a judge? Because it can't just be a subjective comparison of like who can provide a more comfortable life, right?
No, definitely not. The Chapter 751 statute points directly to Chapter 39 of the Florida statutes to define unfitness.
Okay.
To find an objecting parent unfit, the court must find that the parent has abused, abandoned, or neglected the child based strictly on those statutory definitions.
Let's dig into those definitions then, starting with abandonment under Section 39.01, subsection 1. When I read this, the legal logic really stood out to me because it relies heavily on an OR framework.
Yes, the OR logic is the absolute crux of the abandonment definition. Abandonment means a situation where a parent, while being able, makes no significant contribution to the child's care and maintenance, or fails to establish or maintain a substantial and positive relationship with the child.
Right, it's an either-or situation. Let me test a real-world scenario on you then.
Sure.
Let's say a parent visits their child at the aunt's house every single weekend. They play in the yard, they maintain a great positive relationship. But that parent has a solid income and just simply chooses to financially contribute absolutely nothing to the child's care. Could they still hit that legal definition of abandonment?
Theoretically, yes, because there are independent statutory alternatives.
Wow.
Regular contact satisfies the relationship branch of the definition. But regular contact alone does not automatically resolve the separate financial contribution branch, provided the parent actually has the financial ability to contribute.
So you really have to do both if you're able.
Right. And the reverse is also true. Sending a generous check every single week but entirely failing to maintain any positive relationship could also trigger the definition. The petitioner only has to prove one of those branches to establish abandonment.
That clarifies a lot. What about abuse under Section 39.01, subsection 2?
Abuse is defined as any willful act or threatened act that results in any physical, mental, or sexual abuse, injury, or harm that causes or is likely to cause the child's physical, mental, or emotional health to be significantly impaired.
So it requires a willful action or a threat that causes real impairment. And then there is neglect under Section 39.01, subsection 53. I have to imagine this is the most heavily debated definition for parents who place their kids with relatives specifically due to financial hardship.
Oh, without a doubt. It is the most common flashpoint. Neglect generally involves the deprivation of necessary food, clothing, shelter, or medical treatment.
Mhm.
But Florida law makes a crucial distinction here. Financial inability does not equal neglect, unless the parent was offered services for relief and they refused them.
Okay, so abandonment requires an ability to help, but choosing not to. But what if a parent simply doesn't have the means? Like if a parent is just flat broke and loses their apartment, that poverty itself isn't legal neglect.
Right. The state does not punish people just for being poor. The law distinguishes between a voluntary, temporary placement made to protect a child during a hardship and actual statutory neglect.
That makes total sense.
Yeah, if a parent loses their job and their home, and they proactively send their child to live with a grandmother so the child has a warm bed and food, that is responsible parenting. That is not legal neglect. Neglect implies a failure to provide when you have the means, or a failure to accept state-offered services that would remedy the situation.
Okay, so we've established the immense power of the parent's objection, and we understand that unfitness isn't just about who has a bigger bank account. But let's shift gears to the reality of the courthouse. What happens the moment a relative actually files one of these petitions? Because the clock starts ticking immediately.
Yes, and this is where we need to adopt a much more urgent tone,
Yeah,
because the procedural reality is unforgiving.
very unforgiving.
Once a petition is filed, the very first requirement is service under Section 751.04. The court cannot just make a decision in a vacuum and hand over custody. The parent must receive reasonable notice and an opportunity to be heard.
Meaning they have to be formally served with the paperwork?
Yes, they must be served with a petition and summons. This is usually done through personal service by a process server or a sheriff's deputy.
What if they can't be found?
In some cases, if the parent truly cannot be located after a diligent search, the court allows constructive service.
Constructive service, like putting an ad in a local newspaper.
Exactly. It's a legally recognized way of publishing the notice when physical delivery is impossible. But regardless of how service is achieved, once it happens, the clock is officially running.
Which brings us to the 20-day rule.
Yes. Under Florida Family Law Rules of Procedure 12.140 subsection 1, the parent has 20 days to respond after service. And I cannot emphasize this enough. Any parent listening must verify their exact due date based strictly on their own service documents.
Right.
The date of service determines the deadline, and those deadlines are rigid.
Yeah, we aren't doing any date math here on this deep dive because everyone's situation is unique. You cannot guess. You have to look at your own paperwork to know when your 20 days are up. But what happens during this process? There is a hearing requirement too, right?
Yes. Under Section 751.05 subsection 1, the court must hold a hearing. At this hearing, the court will consider the evidence, the claims made in the relative's petition, and crucially, the parent's objections and testimony if they are present.
Here's where it gets really interesting, though. Let's say a parent is overwhelmed. They're representing themselves, operating pro se, without a lawyer. Navigating this pro se is incredibly stressful. And let's say they miss that 20-day deadline. If you don't show up or respond on time, doesn't the grandparent just win by default? Does missing the deadline automatically mean the pro se parent loses their child?
No, it does not.
Really?
Missing the deadline creates a severe default risk, but a default does not automatically decide custody or permanently convert the standard back to a simple best interest test. As established in the Florida case DMM VJM, the Chapter 751 proof framework still applies. Yeah, the court cannot simply rubber stamp the relative's petition just because the pro se parent missed the 20-day window. The relative still has to satisfy the statutory requirements to prove unfitness.
I'm trying to wrap my head around this. If I get sued for a credit card debt and I ignore the paperwork, the credit card company gets a default judgment against me. I lose. Why is family law set up differently? Why is the unfitness standard so incredibly high? And why doesn't a procedural default automatically result in losing custody?
If we connect this to the bigger picture, it comes down to the ultimate trump card in family law, a parent's fundamental constitutional rights. This isn't just about state statutes or local procedural rules. This goes all the way to the United States Constitution.
It's a constitutional shield.
Exactly. The U.S. Supreme Court, in a landmark case called Troxel v. Granville, confirmed that a parent has a fundamental right to make decisions regarding the care, custody, and control of their child. The court recognized that the Due Process Clause of the 14th Amendment protects this right. The state cannot casually interfere with a parent's right to raise their child simply because a judge thinks a relative might do a better job.
It's like the government trying to seize your house just because your neighbor has a nicer lawnmower and a better paying job. The state can't just redistribute children based on who has a higher income or a better school district.
That is a very apt way to describe it. The fundamental right to parent is treated with immense gravity. And Florida has its own strong precedent reinforcing this constitutional shield.
You're talking about Richardson v. Richardson.
Yes, the Florida Supreme Court in Richardson v. Richardson established what we call the fit parent presumption. It essentially states that a parent has a clear legal preference for custody simply based on their status as a parent.
Meaning they don't have to prove they're amazing, they just have to be fit.
Right. Custody should be denied to a fit parent only when returning the child would be actively detrimental to the child's welfare.
This makes so much sense of the Chapter 751 requirements. This constitutional shield is the very foundation for why a judge in Florida cannot just look at a grandparent's big, beautiful house and compare it to a struggling parent's small apartment and decide to give custody to the grandparent based on what is in the best interest of the child.
Exactly. If the parent is fit, the best interest comparison is actually unconstitutional.
The state is not allowed to reassign children to relatives just to provide a more affluent lifestyle. The parent's fundamental rights require that strict unfitness standard to be applied if they object to temporary custody. The Constitution demands it.
But let's look at the flip side of this. Constitutional rights are incredibly powerful, but what if a parent is listening to this and a court has already issued a temporary or concurrent custody order? Maybe they consented initially because they were in a bad spot, or maybe they were actually found unfit a year ago when they were struggling, but now they've turned things around. Are their rights gone forever? Can a parent ever undo the order? Yes, they can. These orders are not permanent terminations of parental rights. Section 751.05, subsections 6 and 7, govern the modification and termination of these orders.
Let's start with temporary custody. If a relative has temporary custody, how does a parent terminate it?
The statute directs that the court shall terminate the order upon a finding that the parent is a fit parent. So if a parent was previously found unfit but has since rehabilitated, or if they originally consented but now want their child back and are fit to provide care, the court must terminate the temporary custody.
Okay, that's reassuring.
I will note, however, that the court does have the authority to require a transition plan. They won't just pull the child out of a home overnight if it would be jarring. They ensure the child is returned in a reasonable, healthy way.
And what about terminating concurrent custody? Since it's shared rights, is it easier to undo?
It is much more straightforward. Concurrent custody shall be terminated upon a finding that either or both parents object to the order.
Just by objecting.
Right. Remember, concurrent custody exists to help, not to replace. Once a parent objects, the mechanism that allows the concurrent custody is undone. Again, the court might implement a transition plan for the child's stability, but the parent's objection is the key to termination.
We have covered a massive amount of legal ground today. We've explored the illusion of automatic custody, the strict unfitness definitions in Chapter 39, constitutional protections, and how to undo an order. So what does this all mean for the parent listening right now? How does a parent, particularly when navigating this pro se, figure out what their very first step should be when the paperwork arrives?
It means focusing entirely on preparation, not strategy. The law requires a neutral, clear-eyed gathering of facts. A parent in this situation needs to systematically verify a few critical things to understand where they stand.
What's the checklist? What exactly should a pro se parent be looking for in that stack of paperwork?
First, they must verify the exact relief requested in the petition they received. Are they facing a petition for temporary custody or concurrent custody? Checking the specific form numbers on the paperwork can confirm this.
Right, because we know those two paths are vastly different.
Exactly. Second, they must verify the dates and method of service. When exactly were they served, and how was it delivered? This is the only way to accurately determine their 20-day response window.
Very important.
Third, they need to verify the facts of their specific situation to see how they align with Chapter 39. They should gather their contact logs, text messages, records of any financial support provided, the exact duration of the child's stay with the relative, and any existing court or Department of Children and Families records.
So the goal right now isn't to rush out and try to find some magic tactical filing. The goal is to neutrally gather the facts and the dates that the law demands so they can properly assert their legal position based on the framework we just discussed.
The law is a framework. The parent's job is simply to gather the true facts that plug into that framework.
This has been incredibly clarifying. But as we wrap up this deep dive, There is a fascinating paradox that keeps jumping out at me from these statutes. It's something for our listeners to mull over as they process all this information.
It really is a profound tension in our legal system.
Think about it from the parent's perspective. The very tools a parent uses to responsibly manage a crisis, like signing medical authorizations so an aunt can legally take a sick child to the doctor, or enrolling a child in a stable school district while the parent actively seeks new housing. These actions are the signs of a responsible parent trying to do right by their kid during a hard time.
Absolutely.
And yet, those are often the exact things that make the parent absolutely terrified that they've legally given away their rights to their family member.
It highlights the incredibly difficult balance the law is trying to strike. On one hand, the state desperately wants to facilitate practical, loving childcare arrangements within extended families, because the alternative is often kids ending up in the foster care system.
Right, which nobody wants.
Exactly. But on the other hand, the law is strictly bound to protect the fundamental constitutional custody rights of the parent. The fear comes from a misunderstanding of how those two goals interact.
It brings us right back to the car analogy. You let someone borrow your car, you give them the keys so they can drive it, you let them put gas in it, but you never signed over the title. The fear of losing your child is real and valid, but as we've seen today, Florida law has distinct mechanisms in place to separate temporary help from a permanent transfer of rights. Thank you so much for joining us on this deep dive. Stay informed, gather your facts, verify your deadlines, and take a deep breath. We will catch you on the next one.
This episode was produced by Bach Pro Se. Run your own legal research at prosay.trybach.com.